All right, welcome everyone. We're diving right into an exam masterclass for contract law. In this session, we are going to crack open some classic problem questions from the Indian Contract Act and the Specific Relief Act. And most importantly, we're going to focus on giving you the exact structure and the key sections you absolutely need to know to ace your exams. So here's the game plan. We'll hit 4 core areas that you'll definitely see, and then we'll wrap it all up with a solid exam strategy. Think of this as our roadmap, laying out the exact steps you should follow in your exam to build a perfect answer.
First up, let's tackle what happens when a contract, one that was perfectly fine when it was signed, suddenly becomes impossible to perform. This is all about the doctrine of frustration.
Now here's a classic scenario you might get. The trick here isn't about a simple breach of contract. Nope, it's all about the personal nature of the agreement. The whole thing hinges on the fact that this contract needs Mr. Chalam's unique skill as an author. That's the core issue we need to attack. Okay, the first thing you absolutely must write down in your answer is Section 56 of the Indian Contract Act. This is the doctrine of frustration, sometimes called supervening impossibility. Basically, it means that when some random, unforeseen event makes the contract impossible to complete, the contract just ends. It's void.
And this right here, this is your model for a perfect answer. Step 1, you point out the personal skill. Step 2, you bring in Section 56 to show the contract is now void. Step 3, you use Section 65, which deals with giving back any benefit you received from a void contract. This all leads to the final step, the principle of quantum merit. It's just a fancy Latin way of saying as much as is deserved. It means his family can get paid for the 4 books he actually finished.
And you can see how this same logic works across totally different situations. Whether it's an orange crop destroyed by frost or a wedding hall burning down, if the main subject of the contract is gone, Section 56 kicks in and the contract is discharged. And notice that last one. Because the rent was paid up front for the warehouse, Section 65 makes sure a fair portion of that rent gets refunded. It's all about fairness.
All right, next up are quasi-contracts. Now these are super interesting. These are situations where the law basically creates an obligation, forcing someone to do something even when there was never, ever a formal contract to begin with.
So picture this. A fruit seller accidentally leaves a box of mangoes at Mohan's door. Mohan thinks, great, free fruit, and eats them. Does he have to pay for it? I mean, he never ordered them, right? The key legal question here is something called unjust enrichment. Did Mohan benefit at the seller's expense in a way that's just not fair? And the rule that sorts this out is Section 70 of the Indian Contract Act. The magic words here are non-gratuitously. The fruit seller wasn't giving a gift, he was running a business. Since Mohan enjoyed the benefit of the fruit, the law says, yep, you gotta pay for it. It's that simple.
This whole idea of preventing unfair gain pops up in other places too. For example, under Section 72, if you accidentally pay a bill twice, they have to return the extra money. But, and this is a huge but for your exams, if an act was meant to be free, gratuitous, then Section 70 is off the table. Intent is everything.
Okay, so sometimes just getting money as compensation doesn't really fix the problem, especially when we're talking about property. That's when we have to look past the Contract Act and use the powerful tools in the Specific Relief Act of 1963.
Here we go. Another classic property dispute. Krishna has the title deeds. He's the legal owner. But Hithan is actually living in the house, claiming it's his. So, as Krishna's lawyer, what specific remedies do you ask the court for?
Now listen up, because this is a top-tier tip for a great answer. You need to talk about this powerful 3-part remedy. Krishna can't just ask for the house back. He has to file a suit asking for 3 specific things. First, a declaration of title under Section 34, so the court officially says yes, Krishna is the owner. Second, recovery of possession under Section 5 to legally get Jitan out. And third, a permanent injunction under Section 38 to stop Jitan from ever bothering him again. Mention all 3 and you're golden.
And don't forget this little gem, Section 19B of the Specific Relief Act. Let's say a seller agrees to sell his house to buyer A. Then he gets a better offer and sells it to buyer B. If buyer B knew about the first deal with buyer A, a court can actually force buyer B to hand the house over to buyer A. The key word you have to remember here is notice.
All right, let's wrap up with 2 really critical topics that love to pop up on exams: agreements that stop someone from working, and the tricky issue of what happens when a contract already has a penalty for breaking it.
Okay, Section 27. The general rule is simple. Any agreement that stops someone from practicing their profession is void.
But there's a huge exception, and it all comes down to one word: reasonableness. Look at the valid example. The assistant can't compete, but only for 3 years and only while he's employed. That's fair. Now look at the void one. Forever and anywhere in India. No way. That's completely unreasonable, and any court would say it's void.
Okay, time for a little math problem. A contract has a penalty clause, 500 rupees for every month of delay. A is 6 months late. But the actual financial loss B suffered is way higher, 6,500 rupees. So, what is the court award? The penalty amount or the actual loss?
Well, the answer is right there in Section 74 of the Indian Contract Act. This section puts a hard ceiling on what you can claim. The key phrase is not exceeding the amount so named. That's everything. It means the claim is capped no matter how much you actually lost.
So, the final amount that B can actually claim is 3,000 rupees.
And why just 3,000? Simple math. 6 months of delay at 500 rupees a month is exactly 3,000 rupees. Because of Section 74, that number written in the contract becomes the absolute maximum. It doesn't matter if the real loss was 10 times that. B is entitled to reasonable compensation, but it cannot go 1 rupee over that 3,000 rupee cap. Period.
So let's bring everything we've talked about together into a clear, simple strategy that you can use to nail any problem question they throw at you in your contract law exam.
Here is. This is your path to a top-grade answer. It's a simple 4-step process. First, identify the issue. What is the real legal question here? Second, cite the rule. Give them the act and the section number every single time. Third, apply the facts. This is where you connect the law to the story. And finally, conclude clearly. Give a direct yes or no answer. Just remember that. Identify, cite, apply, conclude. Drill that into your head and you'll be set.
And I'll leave you with one final thing to think about. We've seen today how one tiny detail can completely change the answer, right? So, out of everything we discussed, which scenario do you think is the most fragile? The one that hangs entirely on a single word or fact? Was it the intent that decided the quasi-contract? The reasonableness that made the restraint of trade valid? Or was it the second buyer having notice that flipped the property sale? Really thinking about that will sharpen your legal mind for the big day. Good luck with your preparation.